Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault.
In front of the
And you're
Walmart.
charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How period does the FBI find people? And people's misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
All right,
What more do you need to see?
welcome to the Court of Public Opinion. I am the Recovery Addict. Whoever, I think it was Kelly H. who got that in front of the Walmart soundbite in there. Perfect timing. You're accused of aggravated assault or aggravated theft or something in front of the Walmart. Yes, that was funny. All right. Welcome one and all as we get ready to kick off Part 2, Day 24, Karen Reed Trial, Round 2. And it's spicy. Mr. Brennan is doing cross-examination and he's bringing the heat. All right, let's turn this down so you can hear me. I apologize. I have to say there are two winners. There are two winners of the internet this afternoon, and we haven't had that before. But Hannah, and Caffeine Queen. Depending on the device I look at, Caffeine Queen is first or Hannah is first. And as we're not able to, as we learned from the witness, when no procedure exists for doing something, it's good to look at all of them. We have to punish everybody. Hannah and Caffeine Queen, congratulations. You are, in fact, first in chat, both of you. And we're going to punish you and sentence both of you, individually and collectively, to internet ownership. And you are each responsible for everything IP-related worldwide, probably throughout the weekend. So does somebody have an expert on timing? We need some logs, some event data recorders in the first in chat category brought in here, because yes, we have two winners, first time ever, and both of you now being winners and in a way losers are justified in doing or have the proper authority to browse to the shopping category on our YouTube channel page and finding that internet ownership certificate and downloading after you pay the applicable 50-cent fine. You can download your own fill-in-the-blank copy of a certificate that indeed commemorates this very occasion. And it says, give it to the Queen. I don't want it, just my certificate. The certificate commemorates you owning the internet. And I think you're going to have to put the work in. I'll let you guys fight it out. But congratulations. Congratulations to both of you. You're now criminally liable for all internet crimes. I will gift my win. I just want the paperwork, she says. Let me out of the responsibility. I just want to put the plaque on my wall and says I was pursuing this and I got it. Chat is not on screen. I apologize. We'll fix that right now. Chat is on screen. Thank you. Let's see. Oh man. Will there be an asterisk on the certificate? I don't know. Anyway, Hannah and Caffeine Queen, they were both just like, I just want, somebody else can take the internet. I just want to be able to say, I won. Well, both of you can now say you won. But somebody has to do the work. You can't both just say, I won, and now let the problems be problems. I'm out of here. Somebody has to do the work, and I'll let you fight this out. All right. But yes, you can browse to the shopping tab of our YouTube page, our channel page. And if you browse deep enough, if you stay here long enough and dig through all the rubble and riffraff, you will indeed find that there's a certificate commemorating this very occasion of you winning the internet. And you can download that. It is a digital copy. It costs 50 cents, but I promise you not a penny goes to me. It's all overhead. I think YouTube alone makes money on this. But download that. That's the lowest price they would let me put on anything, and that's basically the fee I pay to list something. So download that. It's already pre-signed by myself and my boss, Mrs. R.A. All you have to do is fill in the blank with your name, and you'll be good to go. And that applies to anyone who's won the internet by being first in chat. You can download your certificate at any time if you pay the applicable fee. Just know that to win the internet, to rightfully be able to claim that, you have to actually win, and to win, you have to be first in chat. To be first in chat, you probably should click the subscribe button and ring the bell to be notified. That's the best way to do it. And then click the refresh button a lot, I hear helps. All right, Caffeine Queen gifted a membership. Thank you very much. Kelly H. also gifted a membership. Kicking off this afternoon, we had like 140 new members this morning, and now additionals today. Kelly H., thank you very much. OG Boy Mama times 3 says, no way. It's been like 10 months. 10 months. I could have had a kid by now. 10 months. Congratulations, OG Boy Mama. Looks like you already have a kid, so times 3. All right, let's see. I fell asleep, not feeling great. Daffy, I'm sorry to hear that. Did I miss much this morning? You missed Brennan coming out of the gates like a bull in a rodeo. Spicy Brennan, and I like this Brennan. I like spicy Brennan. First of all, whether you're for Commonwealth or for the defense on this one, it doesn't matter. I think you have to admit that Mr. Brennan is a talented lawyer, and he's very good at what he does. And I have to say, he's better at cross-examination than he is direct with his witnesses. He is really, really good at this. And it makes for fun watching, as long as you don't have a dog in the fight. Because he can be brutal. He can be brutal, and he's really good at it. Kills Bells gifted a membership as well. Thank you, Kills Bells. Appreciate that. It's only going to get spicier, says Master Eden. Master Eden, thank you very much. Appreciate it. 16 months, Master Eden. That is awesome. Welcome to the gallery. Much better than Lally. Lally is good. Lally is methodical. Lally is consistent. Lally gets work done. Brennan brings the spice. AJ brings the spice. Alessi brings the spice. Unetti brings the spice. Miss Little gets things done and remembers everything. Every lawyer has different talents, and we have some fantastic lawyers on both sides in this case. It is a wonderful case for that reason, just to be able to see the lawyering happening in real time. Let's see. I think that's subjective. Yes, it's all subjective. I put it this way. I would not want to be cross-examined by Mr. Brennan or Alan Jackson or Alessi or Unetti. Lally, maybe I'd be okay with Lally. I think Mr. Brennan does have defense attorney background. He's obviously a special prosecutor here in this case. Did you see the command suggestion Judy M made that Red seconded? If you missed it, there's a pick in mod chat. Well, let me log into mod chat for the first time today. Hang on one second. Okay, so much talking. Okay, let's see. Red suggested second that motion for Judy M. You need to soundbite only you can trigger that says "Y'all behave" in your best hands on your hips assertive voice. I would need Mrs. R.A. to do it, to record it. Or maybe I could get Brandy Churchwell to do it. I imagine she could do a pretty good Southern mama, y'all get your butts in the house right now or I'm going to whoop them type thing. I think she could do that. I hear Brandy's voice when I see y'all behave, but I'll reach out to her, see what we can do. All right, somebody's going to get a whooping, right?
I think I'm about to catch a whooping.
Mm-hmm. Would it be y'all behave or all y'all? All's y'all? I think you put an S in there somewhere. I'm not sure if it's all's y'all or all's y'all. All's. Yeah, I think it's all. That's the same thing twice. I said the same thing twice.
There's nothing in the order that restrains you from talking to cats.
That's right. There's nothing in the order. We can talk to our cats. Speaking of which, my cat came back yesterday, Kiki.
I don't like podiums, Your Honor.
And pretended he had never left. It was all affectionate, rubbing up against the leg, purring, meowing, wanting to scratch. Yeah.
French lady. To accept, press 1.
Welsh lady's on the phone. Welsh lady, how are you doing?
Hello, Scott. How are are you, my lovely?
I'm doing well. How are you feeling?
Doing well. I had a fall 2 days ago, but who can complain, eh? A few bumps and bruises. Don't know how it goes. Hello, chat. Lovely to see you all, even if I don't agree with
I was told
everyone's
Council wanted to see me inside.
Sorry, the sound effects are going. I'll turn them down.
Oh, I thought the trend was coming back.
It will in a moment.
Come to offer my services.
Oh, for what? Oh, you need
offer my services.
Y'all behave. What is your best?
Well, I can't say that now, can I? Because we don't say y'all, you see. We say you all. But I can say, something like, be nice now, boys and girls. In my best man voice, like you asked me to before.
Be nice. Say that one more time.
Be nice now, boys and girls.
Okay, we got it. We got be nice now. Boy, we might have to make a collection of different accents correcting chat. So sometimes you'll get Welsh, sometimes you get Scottish, sometimes you get Southern lady, sometimes you get me in my grandpa voice.
Yeah.
We'll have to put that together.
Yeah, well, we're related, Scott. So, you've got a Welsh grandfather.
There's only like 6 of you, so Wales is pretty much everyone's related, right?
Hey now.
I didn't mean it like that.
You leave my sheep alone.
Oh, Welsh
It's
lady.
family.
Welsh lady.
That's my family.
I appreciate it. Welsh lady, thank you for volunteering your services.
Enjoying the trial as always, lovely. Please send my love to Mrs. R.A. and Maud, you're doing a fab job.
Thank you so much.
Yes, play nice now, boys and girls.
All right. You've been told with the Welsh accent, so behave now. Awesome. Thank you, Welsh lady. Have yourself a wonderful day.
behave.
Oi, behave. Say
I
that.
can say that word.
Hey, one more time.
Oi, behave.
Hey, I need to get the recorder. Wait. We got to wait for the cue. So I'm going to say ready, go, and then you say it. 3, 2, 1, go.
Oi, behave.
Oh, it cut out. Try it one more time.
Oi, behave.
That was perfect. We'll keep that one. Thank you.
Oi, behave yourself.
All right. Thank you very much, Welsh lady. Have yourself a wonderful day. Great to hear from you again.
I'm doing okay, by the way, my love. Thanks for asking me. Okay, that's really kind. Thank you to all the well-wishers as well. You're all darlings. Thank you.
Thank you. We'll see you.
Take care, lovely.
Yeah.
Bye-bye. See you in chat.
Behave. All right. Thank you.
Bye.
Bye. All right. We have some access. Oh, we have one more. Hang on.
Call from
Donna Turner.
Donna Turner. This is our
Hey.
How are you doing?
Hey, I'm good. First time caller, but I just wanted to tell you how we say it down here. It's y'all better behave or you're going to get a whooping.
There you go. I got it. I recorded it. Hope you don't mind. I'm going to use it without paying you anything. So I figure you called in on the burner phone. It's only fair. So, we've got it. We've got another soundbite. So I'll start putting this together.
Well, I love you guys. I love you, and I'm so glad with what you do because you keep me occupied all day long.
Thank you very much, Donna. Great to call. It's easy to call, right? I don't bite. You get right through.
No.
The receptionist doesn't filter out the call and make sure you're a good caller. You know, everyone's good. It's just me.
It is. I just love hearing everybody call in. I thought, let me call in because I haven't talked to you before, but now I'm glad I did.
Yeah. And you're in Tennessee, right?
No, I'm in South Carolina.
You're in South Carolina. Oh, for some reason I thought Tennessee because we saw it in the chat, but I was going to say I was just
down near the beach.
Like Myrtle? No, that's north. Is it Myrtle Beach?
Yep, Myrtle. Yep, 30 minutes from Myrtle.
Not far from me, really.
No, we're
that's
close.
A quick day trip. So.
Yep.
Awesome.
Well,
Donna, enjoy the beach. Thanks for being here. Thank you very much.
Thank you.
All right. Bye. All right. We are about to come back to court. We're gonna have to focus just a little bit. Focus, everyone. Get together. How about y'all come back now? You hear from Beverly Hillbillies? That's a good one. New road trip. It's always a good road trip when you're going to the beach. I love it. All right. Let's see. Yeah. Welsh lady throwing the sheep comment in there. Oh, man. Let's see. Red, you have somebody to do as far as a good sound effect? Trying to see who that was. Wouldn't want it in my accent, says P. Cooper. Anyone who can road trip with that many kids is an expert. I tell you, we just won the lottery. We won the lottery when it comes to kids. I apologize for all y'all who decided to be parents and did not win, because I did, and I took all the good ones. But my kids are amazing, and they get along, and they have fun, and they're quiet when we want them to be quiet. I credit mostly Mrs. R.A. On that, because it's definitely not my upbringing or what my childhood was like in any way. I was terrible on road trips. Let's see. Susan says, how does months go by so fast? Just love it here with y'all. From Belfast, Northern Ireland, 17 months, Susan. That is awesome. Congratulations. And thank you for your support. Nair Casticlut Tilmezut. Right. Was that Welsh or Scottish? I cannot remember anymore. Was that Sloth Life or Welsh lady who taught us that? Because May is about oot. May's going to be oot after tomorrow. Then we can cast our kloots. All right, here's what I'll do. When court starts, if you'd like, I'll put the burner phone on sort of ignore. And if you think you've got a good y'all get back in line type saying with an accent, and you can do it from a quiet area and nice and clear, just leave them on the burner phone voicemail. And see, like Amber right now, she's leaving one. I'm going to send her right to voicemail, and then she can leave. I think she actually wants to talk to me. Actually, let's see. Amber, are you trying to leave voicemail?
Well, I can't now because you answered it, but don't you dare hang up on me. Because I was going to leave you a clip, but I was also going to make the same suggestion that Gally Mae did. I'm more than happy to go back and get the clips. I had already started working on that anyway for the end of year thing for this year. Ricky Watson had some staple phrases. And if we're going to do a rotating audio clip,
it would be awesome to get some of his phrases.
I think we've got to have Ricky in there.
Great tribute. Okay, we're back. So, Amber, thank you very much. Thank you for volunteering and doing that. All right.
Yep.
Bye.
Whenever you're ready, Mr. Brennan.
Here we go. Whenever you're ready. Buckle up.
Gentlemen, if we could turn to page 6 of Mr. DeSorga's amended PowerPoint presentation.
Amended. Your guy amended it first, Mr. Brennan.
Sir, I want to ask you about your opinions, and inevitably some of the slides that you've presented to this jury regarding adjusting the clock in a time period of 3 seconds. You have given an opinion that there's a difference that you see in the reports between when the defendant's Lexus is powered on and the infotainment system begins. correct?
Yes.
There's a 3-second difference on the exemplar vehicle between when the power is turned on and then the screen lights up, the ignition, the infotainment system.
The 3 seconds I'm referring to is the timestamp in the data from the SD card. So I'm referring to the timestamp in the SD card. It seems that that's coupled to the screen, but I just want to make it clear I'm referencing the data from the SD card.
The data from the SD card correlates directly to the infotainment system itself.
The date does, yes.
Because the SD card is, with the other chips, part of the board that makes up the infotainment system.
Yes.
That infotainment system powers the screen that goes on after a user presses the button to start the vehicle.
Yes.
So the time that the infotainment system is registering is when the infotainment system goes on, not the power on event.
Correct.
So that 3 seconds that was tested with the exemplar vehicle between pressing the button to turn the car on and the time the infotainment system turns on, the infotainment system clock does not accommodate that 3 seconds.
Correct.
So when we're talking about time on infotainment system, we're talking about after the 3 seconds when the screen comes on.
Yes.
Okay. Now you've made some slides and you've made some assumptions suggesting that that 3 seconds should be added to your analysis. And I want to ask you about your analysis regarding the 3 seconds. If we could turn to page 7, please. If you could zoom in on the left side. Sir, you told us that you didn't do any testing or data vetting yourself. You simply relied on reading and reviewing Mr. Burgess's report and Mr. Welcher's report.
Correct.
And really, the information you're reviewing is Mr. Burgess's report. There's only a few references in Mr. Welcher's report where he cites Mr. Burgess's findings, correct?
Most of it is from Mr. Burgess's reports.
There's really nothing in any of Dr. Welcher's reports that you are considering that is not in Mr. Burgess's report.
The .154 alignment methodology, I think exclusively is in Dr. Welcher's and is not present in Mr. Burgess's.
Did you read both of Mr. Burgess's reports?
Yes.
You're not aware that Mr. Burgess talks about that timestamp in his reports?
He mentions it in the second report to say that he doesn't think, basically he doesn't think Dr. Welcher should have aligned it on that.
That is exactly not what he said. Where in the report, where in his report does he say that Dr. Welcher should not have relied on 154? Where does it say that in his report? I have it here. If you can give me the page, we will take a look at it.
I don't know the page, and I'm paraphrasing. By no means am I conveying that as I'm directly quoting it, but I remember that as something I read in there.
Well, I was careful in your affidavit not to paraphrase you, right?
Sustained.
So when you just made that assumption or that suggestion characterizing Dr. Welcher's state of mind or thought process, is there anywhere in the report you can cite or show me where Dr. Welcher said that?
No.
Okay. When you read Mr. Burgess's report and you learned that he and others obtained an exemplar vehicle and did this testing, you have no other independent information to suggest that the power on, power off event and 3 second delay is inaccurate, do you?
I just want to make sure I heard you. Did you say accurate or inaccurate?
Inaccurate. I'm sorry, the fan's on. I'm trying to show.
I know, that's the only reason I couldn't hear that. So can you state it one more time?
I'll rephrase it. When you reviewed Mr. Burgess's report and reviewed the information about his exemplar testing regarding the 3 second difference between turning on the car and the infotainment system going on, you have no other information that you looked at or studied that changes that analysis, do you?
No.
Now, When you are suggesting, could we shrink that and zoom on the right side, please? When you are suggesting that 3 seconds should be added to the time because of that 3-second gap, do you think maybe you made a mistake in considering it that way?
No.
Oh. The time that you're adding 3 seconds to is the infotainment time, the infotainment clock, correct?
Yes.
The infotainment clock begins when the infotainment system goes on. We just spoke about that, correct?
Right.
Which is 3 seconds after the power on event.
Correct.
So you're essentially double dipping. You're adding 3 seconds that has already been separated because it isn't reflected on the infotainment system. Isn't that true?
That's incorrect.
You believe that that 3 seconds between the power on and the infotainment system going on should be accommodated extra on top of it.
It's not that it's extra. It's because when we're talking about times here, we're pulling a time from the infotainment and we're marrying that with a key-on timer from the vehicle control history. Those are separate systems. So if the vehicle control history had its own time, then what you're saying would be correct. We wouldn't account for any delays because then it's already baked into those numbers. But this is a very unique analysis. This is not something I've ever even seen, this type of analysis here where we're comparing a timestamp from an infotainment SD card to a VCH total time. And so the only way to reconcile those two is we have to align them. And the 3 seconds is the alignment between those because the VCH key-on timer is going to start as soon as the vehicle is turned on. And that's the 3 seconds.
You've never seen this before.
I've never seen the approach taken here in this analysis by Aperture. That's what I meant by this. I'll clarify. I have not seen a timestamp from a key-on event in a Lexus infotainment used in addition to the key-on timer from that same Lexus.
You know Mr. Burgess actually looked at the data, not just the timestamp. You looked at the data. You understand that, don't you?
Sure.
You did not, did you?
Which data?
The data for the timestamp on the text stream data.
There is no timestamp on the text stream data, is my point. It's a derived value from the key-on time, and then added to that is the elapsed time from the text stream. So they're separate.
Did you look at the data to make that determination that you're claiming right now? Did you actually look at the data?
Yes. Yeah.
You looked at the raw data?
I looked at, yes, the raw text stream data.
The raw text stream data from infotainment, did you look at it?
I just don't want to mince it. The text stream data is an independent system from the infotainment, and you said from, so they're not.
Did you look at the infotainment raw data?
I did.
Okay. And did you find a timestamp on the infotainment raw data?
Yes.
Now, when you added 3 seconds, you were trying to, in addition to the infotainment data, you were adding on the 3-second delay that now you're saying might not even be accurate. Is that fair to say?
I don't think I've ever said it's not accurate. I said that in the exemplar testing, they documented this behavior of a 3-second delay. And that needs to be accounted for if you're going to correct the timestamps. However, the caveat I put on that was only with one exemplar vehicle. So it could be that this behavior, the 3 seconds, is unique to the exemplar and would not apply to other similar vehicles. And so that's why I did either nothing or the 3, because there's nothing to support something in between.
So you disagree that the clock stamp on the infotainment module begins the run. You believe that there's potentially 3 seconds before when the ignition goes on that should be added to that time.
I know from testing other Toyota systems that the key-on timer happens almost at the identical time that the vehicle is turned on. That timer starts running basically immediately.
But on this case, you don't know anything firsthand because you didn't do the testing yourself.
I don't know if it would specifically apply to this Lexus. I know that from other Toyota testing, but not this specific Lexus.
I'm sorry. Finish.
No, I'm clarifying. I do know that from other Toyota and VCH systems that key on timer is basically simultaneous with the key on. I have not tested it on this, and I don't believe that it was tested by Aperture when they had it either. They didn't document the accuracy of the run timer in their exemplar, so we don't know.
Well, you don't know that they didn't document that.
To be fair, if they did, it was not in their reports.
Right. So in this case, you said cars are different, and that's why you're hesitant to accept the fact that there's a 3-second delay. It's a yes or no question.
I'm saying we don't know. Had Aperture done testing with a separate vehicle, then we could establish, is the 3 seconds the same, or is it unique? We don't know. The answer is we don't know.
And so when you are determining that 3-second variance, you don't have any assurance in your own mind whether or not this car, Ms. Reed's Lexus, has a 3-second variance. That's what you're trying to say.
That's correct, and that's why I run my calculations with and without it.
And the way you would determine that is to actually do testing or look at the data.
More testing, I think, is the only way that would be able to be determined.
Now, let's turn to slide 9. As part of your charts, could you enlarge the left, please? As part of your charts, you took this chalk from Attorney Burgess's report, and you made some assumptions about this, didn't you?
I'm not sure.
Okay.
I applied the numbers in his third column to the times, so I mean that's the extent of the analysis.
When you looked at the first 5 columns, 1:14, 13 a.m., 4:38, 16 a.m., 4:42:06 a.m., 4:45, 12 a.m., and 5:04, 28 a.m. You said on direct examination, oh boy. You said on direct examination that was matching infotainment to iPhone.
That's what it says on the chart, so
Okay.
that's probably what I said. I don't remember specifically, but that's what the chart says.
Is that your opinion, that those first 5 columns are matching infotainment to iPhone?
The chart says infotainment call timestamp in column 1. It says O'Keefe iPhone call timestamps in column 2, and then it says offset. So I'm taking that at face value.
You're basing your later charts on the predicate that these numbers, the first 5 columns, are infotainment compared to John O'Keefe's iPhone, aren't you?
Based on the chart, yes.
You didn't do any study on your own to determine the genesis of that information, did you?
I'm aware of the fact that these calls, the 5 you mentioned, were placed when the vehicle was in a keyed off state. I'm aware of that.
What I asked you specifically is, on those 5 columns, did you do any research or study to determine whether or not it was infotainment matches to John O'Keefe's iPhone or some other phone matches to John O'Keefe's iPhone? Did you do any independent study about that?
No.
Because in your ultimate conclusions and all the charts you've given to the jury and shown the jury, it relies on the conclusion that the first 5 columns are a comparison between infotainment clock and John O'Keefe's iPhone. Isn't that fair to say?
That's exactly how the chart presents it, and that's how I present it.
Did you know that at 1:14:13 a.m. the defendant's Lexus was turned off?
Yes.
Did you know at 4:38:16 a.m. that the defendant's Lexus was turned off?
Yes.
And did you know for 4:42:06, 4:45:12, 5:04:28, did you know that her Lexus was turned off?
Yes.
Do you know that when you make phone calls, oh, by the way, do you know on those different times, the first 5 times, where that information is generated from?
Which column?
Left column, 1:14:13, all the way down to 5:04:28. those 1, 2, 3, 4, 5 calls, do you know where that information came from?
It came from the SD card from the infotainment.
Yeah. Do you know where the genesis, the beginning, the source of that information? That matters, right? The source?
It would.
It would. Do you know where it came from?
The assumption, the assumption is if the vehicle has a timestamp and the phone wasn't connected, it would have been synchronized after the fact. But that wasn't tested. And Aperture didn't do any of that testing in their work to look at the behavior of a timestamp in the infotainment when a phone is synchronized after the fact.
Blaming Aperture is not going to get you out of answering the question. Did you know?
Sustained. Sure.
Okay, Mr. Brennan is about to get his little paws whacked with the ruler because I think he pushed too far. His little comment, he was away from the microphone, but he said, blaming Aperture is not going to get you away from, get you to avoid the question or something. Here comes the little whooping from the judge. This is probably, I think, 5 or 6 sustained, and it's a quick one. It's just don't do this again. Yep, it's done already. Mr. Brennan has to step in line because if he continues here, defense can say, Your Honor, we need to fix this. Put instructions to the jury.
Do you know the genesis, the source of those 4 numbers?
Definitively no.
Your entire premise for your slides and values and ranges depends on knowing the genesis of those numbers, doesn't it?
I relied on Mr. Burgess's explanation that those times were synchronized after the fact.
Did you know that those are all phone calls from the defendant's phone to Mr. O'Keefe's phone?
Yes.
You did know that?
I know that they're phone calls.
From who?
Sorry, can you maybe just state it more clearly? Because I'm not sure. I don't want to fumble through an answer if I don't understand the question. So,
do you know where those calls came from? The source?
a phone.
Whose?
Miss Reed's phone.
Okay. Now, I know you're not an expert on mobile devices, but did you know when it's not a contemporaneous synchronization, when you plug your phone in, it's going to register on the infotainment system, but come from the phone? Objection.
Sustained.
Do you know when someone plugs their phone in after they turn the car back on, how it synchronizes on the infotainment system?
I don't know if adjustments are made to those times during a synchronization or not. I think that's something that could be tested, and to my knowledge was not tested.
If you don't know, then your conclusions and all your opinions to this jury is based on an assumption that you don't even know the predicate for. Isn't that fair to say?
My conclusions are based on all of the data that Mr. Burgess laid out. So he laid these out and went so far as to calculate the offsets himself. So there's something implied in his table by virtue of him calculating these that maybe he would decide to align them. And so, again, to provide the clarity on all the possible alignments, I included them.
But that's not what I asked. If you're making an improper assumption about the predicate, about these calls and the source of them, and you're wrong, that would change your entire analysis and conclusions and charts that we see in your later charts, wouldn't it?
Sure. If there was testing that showed that that is an invalid method on this specific Lexus and SD card, then of the 30 possibilities, some of them would end up being eliminated.
Did you know that when an iPhone is plugged into a car, it downloads the information from the iPhone on the infotainment system? Do you know that?
I don't know how the clocks are synchronized when you plug an iPhone into a car.
Well, if you don't know, how can you make conclusions based on a predicate you don't even know what it is?
The conclusions are based on the data in Mr. Burgess's report.
I know you're not an expert on mobile devices.
Objection.
So,
I'm going to strike that. Go ahead and ask your question.
My apologies. If you have two different devices, a Lexus clock, the infotainment system, and an iPhone, you would agree that it's not unexpected to be variances, correct?
Correct.
When you're comparing two iPhones, do you have an opinion, do you agree that you would expect the variance to be very small, iPhone to iPhone?
I don't know.
Have you ever studied that before?
Two iPhones?
Yes.
No.
So as you sit there today, you don't have any expertise, any education, any knowledge about how closely two iPhones would sync with each other?
No.
Do you see in the first 5 columns the numbers are small, 22121?
Yes.
Would you agree iPhone to iPhone using the same source of time is generally going to be within 1 or 2 seconds of each other?
Objection. Sustained.
Do you have any opinion about whether iPhones to iPhones will generally be within 1 to 2 seconds of each other?
Objection. You can ask if there's an opinion. Do you have an opinion on that?
No.
Next question.
If the first 5 calls are iPhone to iPhone rather than infotainment to iPhone, you agree all of your assumptions and conclusions are inaccurate.
They're not iPhone to iPhone in the sense that column 1 came from the infotainment. The values were read from the SD card. So there's an assumption baked into it. What you're saying that when a phone is synchronized, the infotainment assumes the times of the phone, but we don't know whether the infotainment would adjust those times to its own clock or not.
You're speculating now, aren't you?
We don't know. It wasn't tested. I don't know is the answer.
Don't know.
I don't know.
You don't know.
I do not.
Okay. Don't say we don't know. You don't know.
Objection, Your Honor. Sustained.
So this is iPhone to iPhone. Then your assumption on the first 5, 12121. If they're iPhone to iPhone and you're wrong about the fact it's infotainment to iPhone, your assumptions and conclusions are inaccurate, aren't they?
Objection. I'll allow this.
If the title of the first column had iPhone in it as well, then I would not have used it in my analysis.
But that's not the question. I appreciate that. My question is, if those first 5 calls were iPhone time to iPhone time, and you mistakenly analyze them as infotainment time to iPhone time, then the rest of your assumptions and charts would be inaccurate, wouldn't they?
Objection. Sustained.
Mr. Brennan's mad because this guy caught something that could be a problem.
At 5:21:36, do you know whether or not the defendant's Lexus was on?
I don't recall if that one was an on or an off point. I don't want to guess. I don't recall.
And so if you don't know if that was on or off, were you able to do an analysis whether this was phone to phone or infotainment to phone?
No.
5:30:31, do you know if the defendant's car was on?
That one I know the vehicle was on.
That's one timestamp on the infotainment system, 5:30:31, correct?
Correct.
And then in the O'Keefe iPhone call timestamps, there are 2 different numbers, 5:30:15, 5:30:52. Yes?
Yes.
Right. And do you appreciate that that is 2 separate calls, or do you think it's something different?
I'm going to paraphrase, again, Mr. Birch's report as I recall it, in that he stated during the testing they did with the exemplar, calls placed in close succession would not necessarily both be logged in the infotainment. So as I understand this chart, what he's trying to say here is there were 2 calls placed, there were 2 call logs in Mr. O'Keefe's phone, but only 1 timestamp in the infotainment, and he couldn't determine which it corresponded to because of that observed behavior from testing.
I'm asking if you know.
I don't.
Did you ever look at phone records for the defendant or for Mr. O'Keefe to make a determination whether these are 2 separate calls or not? Did you ever do that?
No.
If these are 2 separate calls, can you explain to us why there is 1 timestamp?
Again, as I stated, that was behavior that was observed. The exact behavior was observed during the exemplar testing by Aperture. I don't know why that happens. Why does the infotainment not log every call? I don't. But I know that it was documented that that is a feature of this system.
This information was not taken from the exemplar vehicle, was it?
This table, no.
No. This information was taken from the infotainment system of the defendant's car. Isn't that true?
Yes.
And the phone calls were taken from Mr. O'Keefe's iPhone. Isn't that true?
Yes.
And so, do you know why there would be 2 phone calls and only 1 timestamp?
Beyond the testing, the exemplar testing that showed an exemplar vehicle did that, no, I don't know why it happens.
Do you know that the infotainment system doesn't always capture all of the phone calls and the phone data in the download? Did you know that?
Yes.
Well, if you know that, can you conclude that even though there's 2 calls and only 1 timestamp, that's because how the infotainment system works?
I think that's the most logical assumption, that that's how it works.
So when you look at 530.15, bottom middle, and 530.52, it is impossible to tell which one relates to the 530.31 infotainment on the left. Compare. It's impossible, right?
Yes.
So there's 2 possibilities.
Yes.
One is that you have a difference, a disparity of 16 seconds.
Yes.
And the other one, going the opposite way, is a disparity of 21 seconds.
Correct.
And so when you add those disparities, you have 27 seconds disparity in those. Correct?
I'll allow that.
Is there a 27-second disparity when you compare the 2?
I'm not sure I understand the math.
530.31 is 16 seconds different than 530.15 on Mr. O'Keefe's phone. Yes?
Yes.
530.31 is 21 seconds different than the 530.52 phone call. Yes?
Yes.
And the difference is cut each way. One's minus, one's plus.
Correct.
So when you add those disparities, you get 27 seconds, don't you?
Objection. I'm going to allow that.
No.
Okay. What do you get?
You're saying, if maybe so I can be clear what you're asking, if we have a negative 16 and we have a positive 21,
Correct.
How many seconds are in between there?
Exactly.
37?
And so you can see.
You got the math wrong.
Did you know that the defense car was turned on at 5:07 a.m.? Does that ring a bell?
I don't have any of those key-ons committed to memory.
So you can see between 5:21 and 5:30, the offset is different between them, which shows that variances change. They move.
That seems reasonable, yes.
When I said it seems reasonable, do you have the experience and the knowledge to agree with me that variances move?
Yes, they do.
Okay. If those first 5 calls were iPhone to iPhone rather than infotainment to iPhone, would you agree they should not have been considered in your analysis?
Yes.
Yes, with the caveat that because this is a novel analysis with this SD card and this infotainment, that it was demonstrated that that's the behavior. My opinions on things like that are based on testing and research and literature. And so when we have a brand new system with new data, we want to see some testing to prove it works the way we think it works. But under the assumption, then yes.
You would agree?
Yes.
If we turn to 10, please. Given, could you zoom in a little, please, on the left? Given that these data points come at 5 in the morning, or 1, 4, 4, 4, 5, 5, and 5:30, did you consider whether they would be less reliable than comparing to the triggering event, the three-point turn at 12:23 the night before. Did you consider that?
Yes.
When you said you reviewed in your critiquing reports, did you read Mr. Burgess's report on May 8, 2025?
Yes.
Did you read in his report where he explains that this is a less reliable method to, it's a less reliable method because of the time distance between the actual event we're interested in, 1162 at 12:31, 43 to 48, than the three-point turn?
Yes.
Okay. When he explains that the method of using 5:21 and 5:30 on January 29, 2022, he explains about how the information is stored in the infotainment system when it's powered back on, doesn't he?
I'm not sure.
Well, do you remember when you were reviewing his report that he explains the available call log correlation is restricted to a time frame between 5:21 and 5:30 a.m. on January 29, 2022, when the vehicle was powered on. All other calls stored in the infotainment module occurred while the vehicle was powered off, indicating those entries were synced from Miss Reed's iPhone upon reconnecting to the system on the morning of January 29th. You considered that when you decided or formulated your critique, didn't you?
Yes.
This further indicated that the associated timestamps for those calls originated from Miss Reed's iPhone. Did you read that?
Yes.
Relative to those first 5 columns, correct?
Yes.
This behavior was previously documented in the initial report, which is the January 30th report. Yes?
Yes.
Well, you shrugged. I mean, I don't want you just to agree with me. Do you remember it was in the January 30th report?
I don't remember how he phrased it specifically. But I think there was somewhere around there where he noted that some calls were placed while the vehicle was off. I think that's basically what it said in the first one. I don't remember specifically.
Okay. Do you agree generally, or can I give you the report? You can look and remind yourself. I want to get your best memory on this.
Sure.
What would you like me to do?
If you'd like me to look at it, I'll look at it.
Sure. Do you have a copy, or would you like me to bring it to you?
Do you have the reports with you, sir?
Okay.
Do you have an extra copy for him, Mr. Brennan?
Mine is marked. Do you want me to show the mark? Let me see if I can get a clean copy from the witness.
I think Mr. Brennan does have a point here. But in making the point, it also makes Mr. Burgess look a little bit bad as
I don't
well.
have a clean copy. I don't want to show you something that has my writing on it. Not that I care that you read it, but it's protocol.
That's a good call,
Okay.
Mr. Brennan. That's the appropriate thing to do.
In discussing why this is not an effective way of matching the time, did you consider in his May 8, 2025 report, when he's talking about this method, when he says, as a result, this method yields a single reference point for potential alignment?
Yes.
And
Call
when
logs
he's
are discrete points.
I'm sorry?
The call logs are discrete points for alignment. Is that?
As a result, this method yields a single reference point, is referring to the 5:30:31.
I don't know. It sounds like it, but I don't know.
From the 5:21 a.m. to the 5:30 a.m. window, a clock speed of approximately -8 and -16 plus 21 seconds were observed between the Lexus clock and Mr. O'Keefe's iPhone clock. Did you consider that?
Yes.
This offset is measured approximately 5 hours after the time of the collision and cannot be assumed to apply to other time frames stated in the initial report. Objection.
I'm going to allow it unless, do you have, I'll see counsel at sidebar.
Hang on one second. All right, sidebar. This is fun. The little exchange we had here. Mr. Brennan had a little bit of a mix-up that we've obviously. I mean, we've seen the same sort of thing on the fence. I think Alessi had a math oopsies as well. So both sides have stepped in it a little bit. Mr. Brennan's the most recent one here was if you add up 16 and 21, you get 26, right? And he's like, help me with the math here. I'm not following. No, you get 27. No, the math is, you get 36. It was just 10 seconds off. It's not a huge deal, but it caused Mr. Brennan it shook him a tiny bit, just because on his punchline moment, he got the math wrong, and it was simple addition. But as a whole, what Mr. Brennan is doing with this witness, attacking the premise of that 3-second shift, if these times on the left on the screen here came from the iPhone, and when the phone was synchronized with the Lexus, when it was, when you plug in and Bluetooth connects, and now you can make phone calls through the Lexus on your iPhone, if those timestamps match the iPhone time, then they shouldn't be included. And that's right. That's what this witness has just admitted to. He'd be like, yes, I'd be wrong in including that in the shift if that's what happened. But at the same time, this witness, Mr. DeSorga, is saying, but they didn't do any testing to see exactly how this ended up. Okay, we're coming back from break, so just 1 second here.
Sir, going back to my question, so you read Mr. Burgess' report, the same report that you're critiquing, and you were aware of this information, weren't you?
Yes.
And so you were aware that Mr. Burgess in his May 8th report was identifying that the section in green was the only contemporaneous information for analysis. Did you know that?
Is that how he states it specifically?
I can read it again. I just read it to you.
If you don't mind.
Okay.
So let's give him a copy.
I'm sorry, Your Honor?
Let's give him a copy. Does he have the clean copy?
Nobody has a clean copy. Quit writing on the evidence, people. Sounds like Mr. Burgess's report indicate he did it properly.
If you can turn to page 3. What I read to you was where it says clock sync method 1. Do you see that?
Yes.
And this is, if you look at the second paragraph, I read that to you word for word. Do you see that?
Yes.
The 5:21 a.m. and 5:30 a.m. are the only two data points when that car was on January 29, 2022. Is that fair to say?
Yes.
Okay. And if you look at the last paragraph, do you agree or disagree? As a result, this method yields a single reference point for potential alignment. Do you agree with that?
No.
Okay. Because you still are under the mistaken belief that
Sustained.
you still have the opinion that the first 5 rows are an infotainment to iPhone analysis.
It's presented as that way in his initial report, which is what my initial analysis was based on. And in the supplemental report, there's no further testing to say one way or the other. He just has a new opinion. So I stand by the initial analysis that I had, that those points should be included with all of the other points.
But that's not my question. My question is, you are taking the position those first 5 calls are an infotainment to iPhone analysis.
They could be, and so I include them. I'm not saying they definitively are or not, which is why I never say there is one way to do it. It's why I say there's a whole host of ways to do it.
So you're now saying that you're not assuming that's an infotainment to iPhone analysis. Are you now saying that?
It's stated that way, and I think it could be that way, but it might be iPhone to iPhone too, if those times are just copied over.
And if it was iPhone to iPhone, your analysis would be wrong.
Certain lines would go away. So if you want to call the whole analysis wrong because of that, it might be your characterization. Okay. It would change the total number of possibilities.
So if we put up chart 12, page 12, please.
It would get rid of the outliers.
If you were wrong about the infotainment to iPhone analysis, and those first 5 should not be considered, which part of your chart would now be wrong?
What do we have? 12 lines on the chart?
I'm sorry?
Yeah, we have 12 lines on the chart. If we decided to eliminate the lines that are based on the calls when the vehicle was off, we would be left with 4 lines on the chart.
Which ones? Which 4? He's going to nail this down and show that those 4 that remain are at or within.
And if we turn to 14, please.
Brennan's going to score this point. He can prolong it, but he's scoring this point.
If your analysis about infotainment to iPhone was wrong, you would agree those first 1, 2, 3, 4, 5, 6 columns should not be there, should they?
No, the positive 16 stays, the negative 21 stays, 1, 2, 8, and 20 would go away. So we'd lose 4 lines from this chart.
And the negative 16 line, that comes from information at 5:30 a.m. the next morning.
Correct.
And you would agree that that distance is not as accurate as cueing it from the 3-point turn event 11:62:1.
The 3-point turn is closer in time than the call at 5:32.
And thus more reliable, wouldn't you say?
Generally.
And the negative 21, that was from 5:30 and some seconds the next morning. Same idea. Not as reliable as the 3-point turn information.
There's greater uncertainty the farther in time we get.
So when we turn to the 3-point turn information, you mentioned in Dr. Welcher's report that it was noted that the timestamp 154 was the end of the 3-point turn event, correct?
That's how he states it.
And then more information was provided when Mr. Burgess then broke down that 154 timestamp, correct?
Correct.
And when he broke down the 154 timestamp, he actually wrote a report about it, didn't he?
Yes.
He didn't just have it in his head, he put it on paper for all to see, yes?
Yes.
And in that report, not only does he break down the data, he also shows a visual of the actual data on a map, doesn't he?
He does.
Okay. Yes. Exhibit 192A. Okay. Let's start with 192B, please. If you could open that up so we could see it a little better. When you look at the data he actually broke down, do you agree that instead of at the end of the 3-point turn event as timestamp 154, that actually is at the beginning of the 3-point turn? Do you agree with that?
I don't know if the points are numbered on here, so I can't tell which point he's referencing as 154.
Do you see the green circle?
Yes.
Do you see the black line?
Yes.
Does that orient you to the direction the car was traveling?
That appears to be what he's trying to convey with this chart.
And then the yellow is facing a different direction, towards Fairview, correct?
It is.
And do you see the green square rectangle?
Yes.
You think that correlates to the green circle?
That seems to be what this graph implies.
Okay. And it notes that...
So ask it differently, Mr. Bowman.
Does that heading note the start of the three-point turn of O'Keefe's phone is 12:23:59?
Objection. I'm going to allow it.
That's what Mr. Burgess states in the report.
And do you have any information to suggest that's not spot on accurate?
No, I didn't do an independent analysis of the three-point turn maneuver.
And then the heading of the change, end of three-point turn to O'Keefe's home, 12:24:07. Do you have any information to suggest that's not spot on accurate?
I did not analyze the three-point turn maneuver.
And so when you look at that and break down 154, did you determine or make an analysis that 154 that was generally accepted, because there is variances between items, when you break it down with more specificity, 154 is actually earlier than the three-point turn conclusion? Did you consider that?
I'm going to allow that, yeah.
I'm not sure I understand the question, if you don't mind.
You mentioned Dr. Welch's report said it relied on 154 as a timestamp for the end of the three-point turn.
Yes.
The report said it relied on 154 as a timestamp for the end of the three-point turn.
Yes.
Based on Mr. Burgess's May 8th report and based on the data which you don't contest, you now agree that 154 was not the end of that three-point turn. It was at the beginning.
Based on how Mr. Burgess presents it, I didn't do an independent analysis. So I'm not on one side with Mr. Burgess or one side with Dr. Welcher. They present independent methods.
Are you suggesting in any way it's inaccurate? Are you suggesting it is in any way inaccurate?
I'm going to allow that.
I don't have any opinions as to the individual accuracy of the methods selected by either Mr. Burgess or Dr. Welcher.
Do you have any information you'd like to add or weigh in on to dispute the accuracy of those times?
Sustained.
And let's turn to the previous exhibit so we can actually see the data that's broken down. If you could open that. The 154 timestamp, if you go to the left, please. Do you see that right above the green line?
Yes.
12:23:58. You see that?
Yes.
And then the green goes to the orange, and that's an 8-second difference, isn't it?
Yes.
And when you looked at this, you considered that this was a more detailed study of that timestamp by Mr. Burgess, right?
More detailed is, yes, that's correct.
And do you know why he did a more detailed analysis of this? Why it wasn't in the original PowerPoint?
No, I don't.
Well, you said that variances are generally accepted in the community, right?
Yes.
But then you wrote a report suggesting numbers and additions, and you submitted that report as part of the basis of your testimony, right?
I only submitted a PowerPoint. I have no report.
PowerPoint. And after you submitted the PowerPoint, isn't it fair to say Mr. Burgess then analyzed this data to be more specific after you introduced your PowerPoint?
Yes.
So can you guess why he went through a more detailed analysis?
No.
Objection. Sustained. Strike it.
In the final exhibit? Let's go back to the data. You said that Mr. Burgess had an 8-second range, 21 to 29 seconds, remember?
Yes.
And you were suggesting that somehow there was some uncertainty. Do you remember that?
Yes.
Okay. Were you guessing about his state of mind, whether he was certain or not? Do you know why he gave an 8-second range? Objection.
So ask it differently, Mr.
Okay. You suggested the reason why there's an 8-second range is that Mr. Burgess was uncertain. Remember saying that to this jury?
Not in those exact words, but that's what uncertainty is. Uncertainty is a range. If we don't know a specific value, we put a range around it. That's uncertainty.
This data from the green, would you agree it indicates the beginning of the three-point turn, and then the orange is at the end when the car is already in motion at 11.2 miles per hour? Objection.
I'm going to allow it. Do you agree with that?
I see speed values there. I see some headings. I can't convert GPS in my head, so I don't know.
You could have analyzed this data yourself, right? Before you came in and gave an opinion.
I could have.
But you didn't.
I did not.
Do you have any reason to test the accuracy of this data that's been broken? Never objection.
I'm going to allow that.
No.
And so by giving the range of 8 seconds, you talked about looking at different values to be fair, a wider range, right? Even though this analysis depends on the end of the 3-point turn, would you agree it's kind of forgiving to give that 8-second range to give the benefit of the doubt by starting at the beginning of the 3-point turn all the way to the end of it rather than just giving the end point?
As to that form, ask it differently, Mr. Green.
Does the 8-second range that is provided by Mr. Burgess coincide with the data and the 8-second range between the green and the orange?
That's where he comes up with the 8-second range, correct.
And so if Aperture's position is the matching times at the end of the event, by going back to the beginning, isn't that even more forgiving than the engaged scientific objection?
I'm going to allow it.
Yeah, I would call it a conservative approach to use a range of values.
Right. The opposite of cherry picking, right?
Sure.
Do you have an opinion to a reasonable degree of forensic data certainty about whether the text stream data provides data reflecting whether a collision actually occurred?
No.
In your opinion, to a reasonable degree of forensic certainty, is the text stream data would not reflect the collision, correct?
That's not what I said. I don't have an opinion.
And you know that there can be collisions or touching between vehicle, and it's not going to appear on the text stream data. You know that, right?
It's possible.
It's possible. Did you know that the defendant's vehicle at 5:07 a.m. on January 29, 2022 bumped into a different car?
Yes.
Do you see that reflected on the text stream data?
I'm thinking back to when I reviewed the raw text stream data, and I don't remember seeing an event from that.
I can't really hear
I don't
you.
remember seeing an event from that time in the text stream data.
Well, you don't remember seeing it. It's not there, is it?
I don't think it is. I don't remember seeing it. I don't think there's one.
You're not.
I was going to finish and say I don't have all of the events committed to memory. There's 19 of them.
I'm sorry.
There's 19 events. I don't have them all committed to memory.
You're not testifying or offering an opinion that there was no collision with this car that night, are you?
No.
Because if you were implying that or suggesting that or insinuating that, that would be misleading, wouldn't it?
It's not.
Sustained.
I have no further questions.
Okay.
We're now going to see on redirect what defense thinks is important from the testimony and if they need to correct it.
Yes.
Thank you. You were asked a number of questions a few minutes ago by Mr. Brennan concerning your expertise. I'm just going to grab a pen if I could. Specifically, you were asked about your expertise regarding mobile data devices. Mobile devices and their data, correct?
Yes.
And were you being truthful when you indicated that you were not an expert in that field? Were you being truthful when you indicated that you have a certain expertise in EDR data?
Yes.
Were you being truthful when you indicated that you did review Mr. Burgess's data and Mr. Welcher's data as reflected in their reports and PowerPoints?
Yes.
Were you being truthful about your credentials?
Yes.
Have you ever lied about your credentials?
No.
You hold a bachelor's degree?
Yes.
And you hold a master's degree?
How long did you pursue it?
You ever lied to anybody about that?
No.
That was a zing.
Mr.
It's a low blow.
DeSogra, what is the only reason you amended your PowerPoint presentation from its original version to the one that you most recently amended it to?
To include the additional analysis and data points from Mr. Burgess's supplemental report, the May 8th report.
I'm sorry, I interrupted you. Go
The
ahead.
May 8th report.
So you amended yours because he amended his.
Correct.
You were asked just a second ago about all the text stream events that you noted on Ms. Reed's SUV, correct?
Yes.
Mr. Brennan asked you about a specific text stream event at or around 5:07 in the morning, and whether you had something like that committed to memory, correct?
Yes.
You said, I don't have them all committed to memory, right?
I don't.
What did you say after that? Because there's how many?
It was 19 events prior to 1162-2, 19 other events.
How about after 1162?
There were a number after 1162-2. I don't have the exact count in my head.
How about after 1162, just on January 29th, going into January 30th?
There were other events.
How many?
I don't recall the exact number.
Does 11 sound right?
That it sounds plausible. I recall seeing in the chart. I recall seeing a number of events after.
Would it refresh your recollection to look at our chart?
It would.
So now we're going to see the other events.
Thank you.
This might take some time.
Yeah, there are a lot. I would have to really use my finger to count them all.
Okay. More than 8?
Total after 1162-2?
Only on the 29th.
There aren't date stamps on these because this chart is the raw text stream data, which doesn't have timestamps.
Okay. Safe to say there are many, right?
Yes.
May I approach?
Yes.
And again, this goes back to a question that you were asked by Mr. Brennan. I want to follow up on. In no instance were any of those related to a collision, to your knowledge, correct?
Objection.
Sustained.
Were any of those that you reviewed at any time, the lifetime of the vehicle, related to a collision?
None of them were triggered by a collision.
Thank you.
Guys, just
I want to ask you a
reminder,
hypothetical, if I could,
we all love
based
court.
on
We
questioning
love
by
watching
Mr.
it.
Brennan
Let's dial down
surrounding
and chat a little bit. Take a step back. We're all friends here.
the 12/32/09 lock event. Do you remember him asking you about those questions about that event?
Yes.
Your analysis was based on the time span. Let me rephrase that. Was your analysis based on Mr. Burgess's and Mr. Welcher's analyses together of a span of time between the 1162-2 text stream event or trigger event and the lock event at 12/32/09?
Objection.
So the question is that what he's considering?
Correct. In other words, was he basing his opinion or analysis on that time frame, at least in part?
So I'll let that question stand.
Thank you.
Yes.
Okay. If you were told that there was another interaction phone event on John O'Keefe's phone at 12/32/16 in the form of steps taken, 36 steps over the course of 83 feet, would that change your analysis or opinion in any way?
Objection.
I'll allow that in that form.
Yes.
In what way?
If the phone event moves from 12/32/09 to 12/32/16, then of the 30 possibilities I had in the chart, all of them would become positive. That would mean that that interaction occurs after the end of the vehicle event every single time. Instead of, it was 25 for 30 in the original analysis. The hypothetical would change it to 30 for 30.
All of them, all 30 of them would occur at a point in time with, let me rephrase that, all of them would reflect a scenario in which the phone interaction took place after the trigger event.
That's correct.
Thank you. If you were told, let me give you another hypothetical, if you were told that there was a Doppler state event on the phone, pocket state event on the phone at 12:33:14, would that impact your opinion in any way?
Objection.
Sustained.
You were asked several questions about what you believed Mr. Burgess may have gotten wrong in terms of his original report and one of his original analyses dealing with bits and bytes. Do you recall that?
Yes.
Did Mr. Burgess...
Hold on.
Of course.
You need to, you know what, we have to turn the fans off.
And I'm not speaking loud enough?
Right.
I'm sorry. I'll raise my voice. I just don't want to scream over people, but I will raise my voice.
Let's try this for a few minutes.
May I start again?
That
Finally,
question,
we can hear.
yes.
Thank you. You were asked about whether or not you believed that Mr. Burgess was incorrect in terms of certain analyses he undertook or reflected in his original report back in January of 2025, correct?
Correct.
As it relates to the bits and bytes, did you find that Mr. Burgess was incorrect or correct about his analysis concerning the size of the data set collected based on bits versus bytes?
He was incorrect.
Explain that to the jurors very briefly.
These are just different units. A bit is a different size than a byte. And so if a size for something is listed in bits, for example, and you look at the data and assume it's in bytes, you will assume it's the wrong size.
Which Mr. Burgess did based on your review of his report, correct?
Correct.
I want to change gears and ask a different question or series of questions about the text stream data versus the infotainment system data, specifically the timestamps associated therewith. Is there a timestamp associated with text stream data?
In this case, no.
Okay. Is there a timestamp associated with infotainment system data?
Yes.
All right. The infotainment system data, well, let me see if I can ask it a different way. Where did the 3-second delay come from? Your analysis of Mr. Burgess's review of the text stream data or his review of the infotainment system data?
The 3 seconds came, well, fundamentally it came from the exemplar testing, where he identified, and he was actually, well, Aperture collectively in that testing identified a difference between when the button was pushed and the time that showed up in the infotainment. But they didn't actually look at, as far as I know, or at least it wasn't provided if they did, how that specifically related to the key on timer itself. But they showed that the button is pushed, there's a 3-second delay, and then the time gets logged.
When that button is pushed for the infotainment system, I'm going to rephrase again, so I'm as clear as I can be. When that button is pushed for the on event, the key on event, is that like a stopwatch? Click, a stopwatch starts running? Timer?
In the VCH system, yes.
Okay. Separate and apart from the VCH system, is there an infotainment system that also has a timer or a clock on it?
Has a clock.
Are those two things independent of one another?
Completely independent.
What were were you doing with regard to the 3-second delay as it relates to the key-on event and the infotainment system event to marry those two things together?
Right. I'm making the adjustment, or proposing that adjustment can be made, because the key-on timer is going to start generally as soon as the vehicle powers on. But the infotainment, when you go and download the data, it will say, hey, I think I powered on at this time, and it turns out that time is actually 3 seconds off. So if you're going to then apply the infotainment time anywhere else to VCH data, you've got to realign the two. And that's where the 3 seconds comes from, is these are independent data sources.
Did Mr. Burgess, to your review of his, insofar as your review of his analysis, his report is concerned, did he align the two vis-a-vis the 3-second delay?
No, he did not.
Thank you. With the court's permission, may we have slide 10 of the PowerPoint?
Okay.
And that is, we've talked a lot about PowerPoints of Mr. DeSogra's PowerPoint. Can you highlight the table on the left, Mr. Wolk? Thank you. Did you create this table?
No.
Was this table, I don't know if you call it cut and paste or if there's some better engineering term for it, was it basically pulled from Mr. Burgess's report?
It was. It was a screenshot.
Thank you. Screenshot. Did you type a single word on this?
I did not. I added a green box.
Put a green box around it?
Yes.
You didn't type anything on this, did you?
I did not.
You were asked a ton of questions just a few minutes ago about whether or not the column on the left and the center column were reflective of an infotainment timestamp versus an iPhone to iPhone timestamp, correct?
That's right.
Mr. Brennan asked you a bunch of questions about that left column being an iPhone timestamp, at least the top 5 rows of it. 1, 2, 3, 4, 5 rows of it. Remember that?
Yes.
Read the name that Mr. Burgess labeled that column.
Infotainment call timestamps.
So what, as an expert, what did you presume he, as an expert, was presuming? Objection.
Sustained.
What did you presume that meant to you, just to you?
Call timestamps from the infotainment.
So if anything is wrong with your analysis, would it be based on Mr. Burgess being wrong in his analysis? Objection.
Sustained.
He basically wants to get to a garbage in, garbage out answer from the witness, but he can't include Burgess in the question.
May I have just a moment, Your Honor?
Sure. Do you need the light on?
I don't. And we can pull that down. What was your entire analysis predicated on? What was it based on? The foundation of it, as you explained your analysis to this jury during the course of the day?
The testing by Aperture and the collective reports and PowerPoint presentations by Aperture. That would be an initial report by Mr. Burgess, an initial PowerPoint by Dr. Welcher, and a supplemental report by Mr. Burgess.
Did you change any of their data?
No.
Did you change any of their analyses?
No.
Did you explain their analyses?
Yes.
Sustained. Ask it to.
Sure. What were you trying to do in terms of your presentation, in your PowerPoint, and the presentation to this jury?
There were a number of different methodologies presented across all of those reports and PowerPoints, and sort of all in different places. So my goal was to bring all of them into one place so we could look at the totality of the data.
You were asked whether the genesis of your analysis relies on knowing the source of the calls, correct? You remember being asked that by Mr. Brennan?
Yes.
The actual genesis of your entire opinion is based on Mr. Burgess's and Mr. Welcher's analyses, correct?
That's correct.
You were also asked why you believed Mr. Burgess did a quote-unquote more detailed report in May versus January of 2025. Do you remember being asked that just a few minutes ago?
Yes.
When you presented your analysis, your math, based on Mr. Burgess's January 2025 report, how many of the scenarios indicated, based on his data and his analysis, that the lock event occurred after the texting event?
All of them.
Thank you. That's all I have, Your Honor.
All right, Mr. Brennan.
So, Mr. DeSorga, this demonstrates the danger or the difficulty.
Hold on. Start the
It's
question
cross-examination.
differently.
It is. It has to be a question.
Go ahead, Mr. Brennan.
This demonstrates the difficulty in giving opinions when you don't actually study the data itself. Isn't that fair to say?
What are you referring to with this?
Well, you're giving opinions, but you can't verify any of the data because you're not relying on your study of the data, are you?
I'm relying on expert reports.
You're criticizing somebody's report, but you yourself can't defend data that you haven't actually analyzed and broken down yourself.
I don't think that's true.
When you're looking at, turn 10 please, when you're looking at someone's report, you're guessing as to what they thought or presumed if you haven't spoken to them. Fair?
I would say I'm reading the words that are in front of me and interpreting them for what they say.
When someone plugs their iPhone into a car after it turns on, and the car reads data that's on the iPhone, that data then resides itself or resides on the infotainment system, correct?
There's a transfer of data. Yes.
And so unless you actually do the study yourself, you had no way of knowing if that information, although on the iPhone, on the infotainment system, you had no idea whether it was from an iPhone or from the infotainment. Fair?
That's right. I don't think that's...
And so when you don't actually do the work yourself, and you just presume or you guess, you could get it wrong, couldn't you?
If I had guessed, yes, but I didn't guess. I used the data in the reports, and I referenced the testing that Aperture did. So I did not make a guess.
1 through 5, and you telling me right now, to a reasonable degree of data certainty, that that information is based on the infotainment clock. Is that what you're saying?
I don't know.
You don't know. But if you actually did the analysis yourself rather than just Monday morning quarterbacking somebody's report.
Objection.
So I'm going to strike it, ask it differently,
If
Mr.
you
Brennan.
actually did the analysis yourself, you wouldn't have to make a presumption that it would be wrong, correct?
I don't think the analysis was possible in this case because the testing wasn't done in this case.
You don't know if the testing was done or not. You didn't do the
Objection,
testing.
Your Honor.
So I need to hear the question.
You don't know if the testing was done or not, do you?
I know it's in the reports. The testing wasn't in the reports.
Did you read Jessica Hyde's report?
No.
Did you read Ian Whitman's report?
No.
You don't know if that testing was done, do you?
I don't.
Objection, Your Honor.
I'm going to let that stand. Next.
I do not, sir.
And so if you're wrong, your assumptions and product are then wrong.
Part of my conclusions would change. I wouldn't agree that I'm wholesale wrong.
Well, as a scientist, if they're not accurate, that would be wrong, wouldn't it?
That might be a nuanced answer.
I'm sorry?
I said that might be a nuanced answer. Frankly, I'm not sure how to give you a good answer to that
If
question.
you have the wrong data when you're doing your analysis, then the final analysis is going to be wrong if you have using the wrong data. It's that simple.
Yes.
Right? You don't have to be a scientist to figure that out.
Yes. That's
Okay. If we could have Mr. Welcher's 33. If you could open that up, please. You were asked about whether the window is within the time frame of 12/32/09, the last user interaction with the phone. When you look at this data, could you go to the top, please? You see on vehicle speed, the car is moving. You see that? Could you enlarge that a little bit, please? The beginning of that data capture, the car's already moving, correct?
I see vehicle speeds, right, in those first couple of lines, yes.
Yes?
Yes, I see vehicle speed.
If you go to the bottom, at the end, the car is still moving, yes?
I see vehicle speeds there as well.
2361. That would indicate, in your experience with text stream data, the car is still moving, yes?
At the end of the record, there is a vehicle speed, the car is moving. That would be my assumption.
Okay. And so, when you're making your conclusions that something's with or without, you're simply talking about the time of the 10 seconds of data. Yes?
Yeah, everything that I've done has been referencing the end of event 1162-2, which is exactly how it's been referenced in all of the other reports.
That 10-second window, yes?
Not even the window, just the end. Everything in the Aperture reports talks about the end of event 1162-2, so that's what I used across everything.
And when you say end of event, you're referring just to data, not the actual real-life event.
Yeah, absolutely, the end of the recording.
Okay. Mm-hmm. And so, after that window, 12:32:04 to 12:32:12, you were asked a question about what might have happened 4 seconds later, 12:32:16. Remember you were asked about that?
Yes.
Did you know at 12:32:16 that John O'Keefe's cell phone moved for the last time? Did you know that?
No.
And between 12:32:12, which is in the 10-second window, and 12:32:16, do you know what John O'Keefe was doing in that 4-second period?
No.
Do you know if he was walking?
No.
Do you know if he was crawling?
No.
Do you know if he was falling?
No.
You don't know.
I do not know.
Okay.
12:32:16 wasn't just that Mr. O'Keefe's phone was moving, there were steps in it, correct?
I didn't review the phone data, so I don't know.
Did you review anything to indicate that the steps were taken over the course of 33 feet?
Objection.
So that's sustained.
You were asked just a second ago, what about the data? What if it's wrong? Then you'd be wrong, correct?
Generally, yes.
Garbage in, garbage out. Basic scientific postulate, correct?
Generally, yes.
AJ, welcome to chat.
You're relying on whose data?
Mr. Burgess's data and Dr. Welcher's data.
Thank you.
All right, Mr. DeSoger, you are all set, sir.
Thank
So
you,
you
Your Honor.
can step down. I'm going to see counsel for a minute. Jurors, feel free to stand up and stretch if you'd like.
It's always good to get a shout out in court, and that's about as close as I want to get in this trial. But good fun. Two great attorneys dealing with what I will say is a very good witness. But the witness was given very limited information, and this is not just in this case. He's an expert in a very limited area. He's given very limited information, and his whole job was to find errors in one report. He found one. He made his report. They saw his report and said, "Oh crap," and fixed their report. And the fact of the matter is, he found the error. It's good. I think as far as this witness goes, believability is very high for me as a juror. I still think the Commonwealth has a very strong case, and the defense should be worried. But I think his demeanor in answering questions to both sides was great. There were many times the witness could have answered. He could have used the garbage in, garbage out response to some of the questions Mr. Brennan was asking, and instead he would just agree when said, "You don't know." He would say, "You're right. I don't. Correct. That's right." His demeanor. I think he took the high road there, which made Mr. Brennan sort of look like the bully in the questioning. and I think kept his believability very high for the witness. So, good stuff. Good stuff. Like both of them, I think we have not been disappointed or let down by the level of effort provided either by the Commonwealth or the defense, as well as the witness in today. As we are on day 24. We're on day 24 of court, I think. We've had 23 days of testimony for the Commonwealth. We're coming back here in just a minute. Judge just gave me the go ahead. Okay, hang on.
Jurors, we did that to have me decide whether I'm going to let you go home now or not, and I'm going to let you go home. So that 5 minutes that just took means that you get to go home, because we know we'll be longer. We don't want to do this to you, okay? So we'll break for the day. I have to give you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Additional caution, please be very careful. Continue to be careful with your social media use. We will see you Monday. Monday will be a full day. And we'll start right around 9 on Monday morning. So we'll see you then. Have a great week.
Please rise to the jury. I don't think we're done. I think they have some more business to conduct. It's only 3:30. I think there's some argument that needs to be done here in court about some issues. So let's hold tight for just a minute. Prosecution took 23 days for testimony. We now had the first day of testimony for the defense. Prosecution called a total of 38 witnesses. 38. They had, 90 on their list? I know defense has a lot on their list as well.
We'll come back. I'll come back in 5 minutes for the voir dire.
Oh, we get a voir dire. Yeah. I love voir dires are great. First of all, voir dires are fun because the jury's gone, and it takes makes the questioning just a little bit different. Okay, jury's gone home. We get a voir dire. Of who? Is it going to be one of the proposed witnesses? Is it this guy? Is it Lucky Proctor? Who's on the hot seat? That's my question. Who's on the hot seat? All right. Who are we VDing? I don't think we can say VDing. It's good stuff. They're often spicy. And as spicy as the voir dire is, it's usually a toned-down version of how it's going to go in court. A lot of times in court, it gets a little more bang. You get a little more bang for the buck, and the answers are even better. But good stuff. We'll take it for sure. Get this replay ready. Okay. No questions about how much money this witness earned. Clearly an expert witness. No questions about how long he was retained for, when he, how long he's been billing, number of hours he's put in, the rate he charges for his appearance. It's usually the defense team that points that out, in my experience. But Mr. Brennan did not go there. Plus, I don't think he'll go there for any witness, because maybe, unless possibly ARCA, just because his witnesses cost so stinking much. They were so expensive. $400,000 to Aperture. The others aren't going to compare at all. David Little just gifted a membership. David, welcome. First of all, it's great to have you as a member. Thanks for your generous gift as well, letting somebody else be a member as well. And that one went to Lisa Wilson. Congratulations, Lisa. Thank you. We've had nearly 145 gifted memberships today. You guys are absolutely amazing. Let's see. So who comes next? Court is done for the day. Only for the jurors. We've got a voir dire, or a voir dire, or a voir dire, or voir dire. We need a poll of how to say this. I have no idea how to say it. We've got a few minute break. Judge said 5 minutes. Let me go, brush my hair and freshen up for this. It's going to be good. So we've got Ivan on the phone. Ivan, how are you doing, my friend?
Hey, I know I just got a minute here. I'm hoping I can speed it up with my usual reaction and how things shake out when I call. So But how are you, man?
I'm doing fabulous. I'm loving it. This is a good case. I mean, I don't like the drama that surrounds the case. I wish there was none of that. But we have top level lawyers, pretty good audio, an intriguing set of facts, and some great personalities to watch. Some that we like more than others. But this is my happy place when I get to watch court like this.
Well, and I'm just going to offer one more thing that we may not have, but there are certain people who have. And, you know, I was skeptical of this whole second process after I saw how the initial process went. And I wasn't all that shy about it. But just looking at what the money says.
By money, you're checking the bookies, right?
Right. As it stands, if Karen, and a lot can change. I mean, it just started as a defense case. So, right. I mean,
I would expect right now on the books, I would expect the defense to be winning at this point. Or sorry, the prosecution. What? I would expect the prosecution to be winning right now.
And so would I. But that being said, if she were to be found not guilty, it would be the single largest upset I would have ever seen with these books.
Wow.
Why? I don't know. That doesn't really necessarily matter with what I look at, for what I care about. But everybody can take their own guesses. But it's and certainly it will level out a bit because they're going to have their moments and one-liners and witnesses and all that. But
so the bookies that are doing this calculation on the outcome, first of all, I think it's crazy that they bet on court cases. Second of all, are they saying any guilty sentence, or is it manslaughter versus second degree?
Of course, there are different shakeouts that you can bet on, but a straight acquittal is almost basically a straight acquittal. RA is I would have a better chance of having everything I've ever done pardoned and then apologies written by each of the arresting officers.
Are you saying that's not going to happen? Don't hold your breath.
Hey, I'm just throwing odds, that's about where that stands. So now when you start getting into the, lesser charges and that, it's frankly, I hate lesser charges. So it just bothers me even reading about all that. I think it's, horrendous deck stacking and get what you want to get and charge accordingly. And that's another phone call, I suppose. But
we've had that discussion a number of times.
Right. I just don't know what I think people are probably looking at it with a bias that the jury isn't privy to, of course, because they all saw the first trial. And I think they're probably saying to themselves, what I am, is there was a new approach by the Commonwealth. There isn't anything new that the defense can really do. So they are at a disadvantage in that regard. Yeah. What else can they say, right? Like, what else is there? They don't get to do another theory or whatever. Like, that is certainly where the Commonwealth has the advantage, in my opinion. Like, they get to come out with a new, however they wish to go about prosecuting it. And when you're saying it's not me, all you can do is say it's not me. Like, what else can you say? So, I know, that's my opinion. I'll let you go.
What was the first trial odds? Do you remember?
I don't remember. And truthfully, I didn't even cover or watch it that closely because I really didn't. Like, I would just pop in on your replays here and there. And because, like yourself, you
were a busy man back then. You had some things happening. So.
Yeah. Well, and the drama of it all, like, really kept me away from it with all the people making themselves part of the story and all of that sort of behavior is, people who make themselves part of the story, if you're going to do that, you better be interesting. And they were. So that's kind of where I lost interest last time. So anyway, I'll let you fly. Love you guys.
Love you. Thank you, man. Thanks for the call. Catch you later, Ivan. Bye. Ivan, our favorite ex-con with us here, not shy about it, has had some experience that's given us a lot of insight over the years of trial watching, as he's got some background experience that many of us do not have, and it gives a lot of it's interesting. It's interesting. Always love talking to him. He's a great friend, both on the air and off. Let's see. Amber says, for your information, one of those post-trial motions I found in a civil state case, judge cut Welcher's invoice of $300,000 to $120,000 because fees were disputed. I haven't gone over those documents in detail yet, but it's always bad when the judge says you can't bill that much. You're not worth it. Let's see. Do you think Proctor will be called? He's on the list. The defense has said if they don't, we will. I think they want to. I don't know if they'll get to. Super T says, y'all, I'm not a happy camper right now. Can you believe the Weather Channel app now requires you to purchase app upgrades in order to view the radar map? It's disgusting. I do know there are some competing radar maps out there. Some, I think even, doesn't Ryan have his own app now? Or an app that's Radar Omega or something? I'd have to check with WeatherWatch to see. Is that the garbage truck? It's Friday. What's the garbage truck coming by on a Friday? Why would they be able to call Proctor? A couple things, CGC. One, the easiest way to not get called to court is not be served the subpoena. How do you not get served the subpoena? You be unfindable. Find a little secluded spot on the French Riviera and hang out for a month or two. That's one way to avoid testifying in court. I don't know if he's going to be called or not. Clearly, the Commonwealth says we can prosecute this case without him, and they did. They rested their case, never called him to the stand. But Ryan now uses WeatherWise. It's free. Greater Omega is $10. So Sharkey. Ivan's mullet got it wrong once. I'm approaching the mullet stage. I'm starting to have to
unmuted.
Comb my hair in circles to keep it all in my head. Today I'll get it cut though. We're back. Let's see who's up. Big sigh from the judge. I'm going to count that one.
Close now open, maybe see.
Another sigh. Brings us to
So you're going to step up, take the
214.
question, raise your right hand.
You solemnly swear the evidence you give the court in the case now and hearing to the truth, the whole truth, and nothing but the truth, so help you God. Thanks. You take
Who
the
have
stand.
we here?
Thank
Hang
you.
on, hang on.
I know this is a reluctant opportunity. There is a witness outside. Do you have her ready for the testimony begins just to get her?
Sure. Is she right outside the door?
Last time I checked.
Do you mind, sir, if you can stay right there? Sure. And it'll just be a few minutes, okay? Ms. Giannetti, when do you need this witness back? Monday?
Another sigh. Mr. Giannetti? They said somebody's right outside the door? She's coming? Who? What is going on? Another sigh.
So I'm going to need her at a microphone. Do you have one on counsel table there? So the podium, or one of those back where Eugenia is. Thank you.
We've got two people on once. Oh, what in the world?
No, there's a microphone a little closer. We're just follow the.
On the bar there. Another big sigh. Judge is not happy, and I think we know that now.
Hi, good afternoon.
Hello.
Could you tell me your name, please?
Kelly Dever.
And Ms. Dever, you've been summoned here. I think I saw you earlier. You've been here all day?
Yes.
All right, so we're not going to reach you today, unfortunately, but you were summoned to be here?
Yes.
All right, so that summons is still good until we reach you, so you're going to have to come back Monday morning, okay?
Yes, ma'am.
Do you agree to do so?
Yes, ma'am.
Okay, thank you very much. We'll see you Monday morning. Be here before 9, okay?
Will do.
All right, thank you very much.
Thank you, Your Honor.
So the summons was only good for one
Go
day.
ahead, Mr. Alessi.
Judge extended it.
Oh, geez, Giannetti.
That was a big compliment, Your Honor. Thank you. Good afternoon, sir. Would you please state your name and spell your last name?
Jonathan Diamandis, Diamandis.
You've also been here all day.
Yes.
Sorry for making you wait.
No problem.
Do you know former State Trooper Michael Proctor?
I do.
How do you know him?
I've known him since middle school, probably the 6th grade.
It's a text,
grew up with him, essentially?
Grew up with him, been friends for 30 years.
Okay, and if you just keep your voice up,
Sure. Yeah.
I'm sure other people can hear you, but this old guy.
Can you turn off the fans and the air conditioning? Are they all off?
Yeah, she's going to shut that down.
We're just going to do that, sir, so that we can get through this a little bit.
We just like to make you sweat when you're on the
Much better,
stand.
thank you. So you say you've known him since middle school, elementary school?
Yes.
Graduate high school with him?
Yes.
And are you friends after high school as well?
Yes.
Do you have his cell phone number in your phone?
I do.
Have you texted with him over the years?
I have.
In fact, were you on a group text chain with him that lasted a number of years?
Yes.
I would like to show you a document, sir, and I'm going to ask you to read it to yourself, familiarize yourself with it, and then when you're done, look up at me. Okay?
Okay.
May I approach?
Yes.
If the judge allows this,
Yes.
if the judge allows this, this will be replayed again. We'll go through the same questions in front of the jury at some later point in the trial, or possibly additional questions beyond that.
Exhibit NNN for identification.
And now I'll give it back to the witness.
Thank you.
Oh yeah, this one. Now, I hope the guy's just straight up truthful and just answers questions. Don't take one for your buddy, first of all. But this guy, he had no dog in the fight. He's just a friend of someone who was involved, and now he's getting a subpoena to court to testify. I tell you, this is not the first time he's reviewed this. Let's print out of the chat. It's like a Band-Aid. Just rip it off. Get the pain over with. If it happened, it happened. Own up to it. Say you're not proud of it. Say you should have done better if you had any part of that should have been done better, and get off the stand. But mean it too. You can't just apologize and not mean it. Kelly Deaver, spelled Denver on a Commonwealth filing today, I think, or yesterday. Spelled her name wrong. It's my understanding that this witness was in the group of individuals who were texted information about the case, about the Karen Reed investigation by Michael Proctor. So they received some information and had some discussion at some point during this conversation. A little shake of the head there. Let's see if he develops a case of amnesia regarding this conversation. He's already testified he was part of this. Here we go.
I think he's all set, Mr. Union.
Thank you, Ronald. Sir, have you reviewed that entire document?
Yes.
Does that look familiar to you?
Yes.
What do you recognize it to be?
It looks to be a text chain with a group of my friends that I grew up with.
Okay. And so would all of those friends have been people that you went to high school with?
Not all the same high school, but the same time. Some of us went to different schools.
And you were friends during that era?
Yes.
And you've remained friends for how many years since then?
I mean, we've been friends for 30 plus years, probably.
Do you know precisely when that text chain started?
I do not know when the text chain started.
Months, years?
Years. definitely years.
And that's a portion, in other words, there's a start time and an end time to that, but the text chain started before the start time that's listed on that document?
That's correct.
Now, I'd like to ask you about 5 different categories of information that allow you to identify the text chain. First of all, directing your attention to page 1. That is an unredacted version of this. Do you see your phone number on page 1?
Don't say it.
I do.
And is that accurate in terms of your phone number?
It is.
Well, do you have a passcode on your phone?
On my phone, yes, I do.
All right, and have you had that for years?
Yes.
So as of January of 2022, you would have had a passcode to get into your phone, correct?
Correct.
With regard to the typing of text messages, you didn't appear to be too active on this thread, is that correct?
Not from what I see here.
Did you see one entry that you actually did text?
Yes, one.
Okay, and I think these page numbers, they're all numbered. Could you direct us to the page where you actually chimed in? And if I suggested to you, it might be 4 from the end. And you don't have to read the actual text, sir. I just want to...
Sure. I'm just trying to locate it. Yes, I see it.
Okay, and the time of that, date and time of that text as it's reflected on this document?
February 2nd, 2022, 12:38 p.m.
Okay. And what you type...
I have a different copy.
Oh, I'm sorry. It's for the record, it's on page...
What's the bottom page number? So what are the last 2 digits? 4.
And for the record, reading what is typed there, does that sound consistent with something you might chime in a text message, a text chain of this sort?
I mean, it could be. I have no memory of actually typing it, but
sure,
that's not something. I mean, it could have been something that I would say. Yeah.
At the very last line of that text, do you mention somebody's nickname?
Yes.
And what nickname is that?
Chip.
And whom do you know as Chip?
Michael Proctor.
Now, going back to the first page, there are a number of other phone numbers there. Have you checked your phone prior to taking the stand today to match those phone numbers with other friends of yours?
Yes.
And if you could, and hopefully you remember them all, can you list by first name only your friends who are included in this text chain?
Sure.
So, I don't think it's necessary. Yeah. So let's not... If he recognizes it, I don't want to put names out.
Oh, I don't either, Judge. That's why I was saying first names. But if that's sufficient that he recognizes...
Why don't you refer to the last 2 digits in the phone?
Sure.
Is that acceptable, Mr. Brennan?
It is.
Okay.
Okay. You see, I'll list the last 2 digits of the phone numbers that don't have a name associated with them. Okay?
Okay.
If I may just have a moment?
Yes.
Doesn't want the names out there. Even the first, I'm surprised that first names, I would say first name and even last initial would probably
Okay,
be
starting with the phone number that ends in 51.
Oh, that's me. Sorry.
After
No,
you checked your contacts, is that a friend of yours?
Yes, it is.
Who was on the text chain?
Correct.
With regard to the phone number that ends in 68, same question. Is that a friend of yours who was on the text chain?
Correct.
And with regard to 45, which is the next one, again, a friend of yours who was on the text chain?
That's me.
Oh, I'm sorry, that is you, of course. With regard to 95, is that a friend of yours who was on the text chain?
Yes, it is.
And with regard to 93, same question, friend of yours on the text chain?
Yes.
And then there are 3 numbers there, one that ends in 11, one that ends in 46, and one that ends in 82. Do you see that those particular numbers have a nickname associated with them?
Yes.
Those nicknames, do you recognize them as being also friends of yours who are on the text chain?
I do.
And then finally, there is somebody listed as local user. We'll get back to that one.
Okay.
With regard to the other ones that you've just identified, sir, have you texted back and forth with them on those phone numbers over the years?
Yes.
And also with regard to this particular text thread?
Yes.
All right. Now, I'd also ask you, with regard to the content of these messages and who said what, and particularly focusing on the one that's identified as local user. Having read that text chain, were you able to determine who local user is?
Yes.
And who is that?
Chip. Michael Proctor.
And was that by the content of the messages that Michael Proctor typed that you recognized it?
Yes.
And with regard to whether this is a complete, accurate record of what it purports to be, what is your testimony in that regard?
I believe this to be a record of our text chain for this period of time.
Appears to be accurate and complete.
It does.
If I may have a moment, Your Honor.
Okay.
We missed Ricky Watson. He did pass away unexpectedly. A good friend of the channel.
Just one more question for you, sir. Does the text message chain that you read fairly and accurately represent the circumstances of the conversation that was going on?
Yes.
Nothing further.
All right.
Mr. Brennan?
Good morning.
Good morning. Good afternoon.
Do you have an independent memory of any of the text conversations in the package that you reviewed?
I do not have a memory of this happening.
Thank you.
Nothing on that.
All right. So, sir, I'm going to ask you to you're all set.
Okay.
I'm going to ask you to step down.
Okay. Thank you.
Your Honor, given that unfortunately this witness was not reached by the jury today, I would like him recognized as well.
He has counsel here with him, right? Does he have counsel here with him?
Yes,
all right. Sir, you'll make sure your client is here when we need him?
I will do so, Your Honor.
All right. Thank you.
My name is Thomas Campbell. My office is in Boston.
And I'll speak with Mr. Campbell in terms of an appropriate time of day. He's been very cooperative.
All right. So, sir,
It's always good when a witness brings
Thank
their
you.
lawyer
right, and
to court.
thank you, Mr. Campbell. We'll see you. We'll let you know when we need you back. It's probably going to be Monday first thing.
Understood.
Thank you.
Sir, watch your step coming down.
It's probably going to be Monday first thing. So basically, this will come in. This will be
Okay.
allowed.
We'll hear you, Mr. Yannetti.
So, Your Honor, my understanding is there's an objection, so I'd rather respond to the
No,
objection.
I want to hear you as to why this is admissible. Why this is admissible.
That's fine, Your Honor.
Please go to the mic. Please, please, please. People in the courtroom cannot hear very well. We have microphones to help us hear a little bit, but the fan noise is bad. We can't hear him when he's away from the mic. There we go.
So, Your Honor, with regard, I assume we're just dealing with authenticity at this point?
No, we're dealing with both. You're the proponent of the testimony, so let's deal with both.
Okay. All right. So, regarding authenticity, Your Honor, there are several ways that are either independent or connected with each other by which or through which a party can authenticate text messages. The majority of the case law out there are defendants having appealed judges' decisions to admit text messages offered by the Commonwealth, and the majority of the case law that exists affirm judge's allowance of text messages into evidence. The Commonwealth filed a memorandum in opposition to these text messages being admitted, and not one of the cases cited by the Commonwealth apply here or are appropriate. The case of Commonwealth versus Purdy, in that case, the Commonwealth introduced text messages from computers seized at a massage parlor. The defendant objected that there was no evidence that he had authored any of the, these actually were emails, not text messages, any of the emails that were admitted into evidence. Nobody saw him do it. Nobody saw him type it. And nobody discussed any of the emails with him. But the SJC cited a long-standing rule, including Rule of Evidence 901B1, evidence may be authenticated by direct or circumstantial evidence. And the circumstantial evidence is essentially what we covered here in court today: the appearance of the electronic communications, the content, the substance, internal patterns, or other distinctive characteristics. Commonwealth versus Welch, it was a murder case where a boyfriend killed his girlfriend, was charged with killing his girlfriend, was convicted. The Commonwealth sought to introduce text messages between them, and various text messages from the victim's cell phone were admitted into evidence because, for one reason, they referenced the defendant's distinctive nickname. And in this case, we have a text chain with 3 nicknames, all of whom the witness recognized as being his friends. We have more to authenticate this text chain than in any case I have seen, and also more than in any case the Commonwealth has cited. In this case, we have an identification of every phone number pursuant to the last 2 digits. We have an identification of Michael Proctor's message relating to the contents. We have evidence of the witness's cell phone requiring a passcode, meaning that in order for his phone to be active in this chain, he would have had to have unlocked the phone with the passcode. And he testified that what was in the content of the message that he identified as being his is consistent with something that he would have said. And not only that, but he adds a 4th nickname, that being Chip, that being Michael Proctor. The Commonwealth, with regard to Commonwealth versus Welch, which is again cited in their memorandum, this opposition, Your Honor, they state what appear to be rock solid black and white legal principles, but when you scratch below the surface and you actually read the case stands for nothing in terms of what they've represented it to be. They stated that in Welch, the court must find that each and every communication was authored by the individual member of the group. That's just plain false. The case doesn't say that at all. It's nowhere in that case. And in fact, the messages were let in, again, because of the circumstances and the content of the messages. Commonwealth versus Raposa, another case that they cite. The defense sought to call a neighbor to testify that he had seen the victim alive after the defendant had confessed to having shot him, another murder case. The problem was that the neighbor denied making the statement, so the defense wanted to call the neighbor for the sole purpose of impeaching him with his prior statement that he supposedly made to the police and use that statement as substantive evidence. So in that case, the defendant wanted to use an out-of-court statement for its truth. It was rank hearsay. That case had nothing to do with text messages or statements used to show state of mind or electronic communications. But somehow it makes its way into the Commonwealth's memorandum. Commonwealth versus Rajiv R., which is the second to last case that they cite, that dealt with a search warrant done at a juvenile's home. The police officer in that case was allowed to testify to what he was seeking, which was the goal of the search warrant, a firearm allegedly in the juvenile's possession. And he was also allowed to testify to what the juvenile's mother did during the execution of the search warrant, which is she directed the police to the juvenile's bedroom. The Commonwealth cited that case to say you can't use hearsay when trying to prove a Bowden defense or present a Bowden defense. That case had nothing to do with Bowden. The evidence was admitted to explain what the police were doing in the home. So it's a situation where, there are times when, the police stop somebody on the street, or the police get a search warrant and then they show up at a home, and rather than just have them magically appear at the home with the warrant, the police are allowed to give some circumstances as to how they got there. Nothing to do with Bowden. It's just giving the jury a fuller picture. Yet it was represented to you by the Commonwealth that, geez, this is a Bowden issue and you can't use hearsay to present a Bowden defense. Commonwealth versus Sullivan, exact same situation. Testimony was admitted about DNA on evidence matching the defendant's DNA from a national database. The Commonwealth cites 3 principles. It's almost like they're setting a standard down that the court is supposed to follow with 3 factors. But again, none of the 3 principles that the Commonwealth cites is found in Sullivan at all. They're not even mentioned in the case. They're simply made up and put in a memo to ask this court to do something that the case does not support. And again, it has nothing to do with Bowden. So now we come to the arguments.
They made up case law?
The fact that the Commonwealth is claiming that these statements are hearsay. They're not. These statements contain insults of my client. I'll be kind and just mention the word.
So I read them.
Yes. Okay. Well, I mean, Your Honor, if you're going to allow this into evidence, I'll stop talking. Otherwise, I have to make my argument.
I understand what you mean by insults.
Okay. Okay. So I won't even mention them then. The Commonwealth is essentially arguing that we're offering these text messages to show that the insults were true. That's a silly argument. Obviously, we're not. Hearsay has 3 components. These are all statements out of court. None of them are offered for the truth of the matter asserted. None of them. Even the statement when Michael Proctor says that the homeowner's not going to catch any grief because he's a Boston cop. We don't know if that's true or not true. It's offered to show that Michael Proctor believes it's true. He's the lead investigator in the case. He has input into the case. He can decide who's investigated or not investigated. At least that's our argument. It's all consistent with our defense. It's offered to show his state of mind. Everything that he says is offered to show his state of mind and to show his bias. He, as the lead investigator, his bias in what he does or doesn't do. And in fact, Mr. Brennan said at sidebar earlier when we started this conversation that Bowden deals with what was done or what was not done. We're entitled to explore what was not done and not done, and we're entitled to explore why. We have evidence of why. We have Michael Proctor's words about why he did or didn't interview people separately, why he waited, for instance, a year and a half to interview a plow driver who was out there on January 29th, why he treated some people with kid gloves and other people with brass knuckles. He's stating it in these text messages. She's going to go down for this. We're going to pin it on the girl. We're going to make sure that there are some serious charges. She's effed. Those are what he says about, those are the statements he makes about Karen Reed in the infancy of this investigation. And to the contrary, is anything going to happen to Brian Albert? Nope. He's a Boston cop too. These are all statements about Michael Proctor's state of mind. The prosecutor and I have been over the statements. I realize he's objecting to the admission of these statements. I don't think he has a legal argument that passes muster to do that, but should the court allow them in, we're agreed on everything except for 3 entries which I think we could deal with pretty quickly. And unless the court has questions, I'd rest on that.
No, but I'd appreciate a copy of whatever you've agreed upon.
Okay.
So it's been a long day for staff, so I don't need to sit here and go through each one. Just get me a copy of what you've agreed to.
Okay.
Staff has worked
this is the
6
only
minutes of
marked copy.
overtime.
I'm happy to hand it to the court.
And you can take care of it and email it in.
We'll do that. Thank you, Ron.
So, Mr. Brennan, I'd like to hear you on admissibility. I haven't decided admissibility, and I'll hear you on authentication.
Take your glasses case, Mr. Yannetti. Otherwise, Mr. Brennan will crush it in his anger.
On the first issue of authenticity, this witness has no memory of any of the text messages. I think it's fair to conclude he's on the text message string. He recognizes the people on it. But there is no authenticity if he doesn't recognize them. The person that could best authenticate these text messages is Michael Proctor.
Where's he?
This witness does nothing as far as identifying the individual text messages and whether they're reliable, whether there's been any additions, deletions, whether in sum and substance this is part of the conversation. Notably, I think, according to the questioning by Attorney Yannetti, he's made one comment at the end of the string that really has nothing whatsoever to do with the text messages that are at issue. So authenticity, I don't believe this witness reaches that conclusion for them. Regarding admissibility, I do not dispute that in the right context, these text messages are admissible. If there is an investigator in a case that makes derogatory remarks about an accused, I can't say that doesn't go to bias, nor do I reject the idea that it shows an unfairness or a motivation. But really, you need to put that in context, and I think Attorney Yannetti highlighted that. He says that this is not hearsay, it's how he thought, or whether it affected a particular part of the investigation. It may have, it may not have. Even if he denies that it affected his investigation, it's still an appropriate question to ask just because that type of negative commentary, inappropriate commentary was made. But to explore the state of mind and put it in context, you need to ask the person that you're accusing of having the bias. Because perhaps it did affect the bias. Perhaps the person was very biased and made decisions based on that animus. Or perhaps the person made negative comments but had nothing whatsoever to do with the investigation. It is surmised to say because these comments were made, a witness was not investigated, or there was some other amorphous, undefined ill that happened. That's the whole reason why the witness who made the comments should be confronted with the comments they made so the jury can fairly assess, is this relevant, is it material, and what is the value of it? I am not opposed to the admission of bias against a witness, especially a police officer, but it should be against that witness because they need to have the opportunity to admit, deny, define, accept, and explain. By putting these messages in with sidestepping, calling Mr. Proctor, they are trying to gain the advantage of putting information in front of the jury that has no context, suggesting it has a value that has not been defined, and then, as Mr. Yannetti just did, making an argument that because the comment was merely made, that therefore there was a consequence, and specify a consequence where there's no factual basis to conclude. Because he made a derogatory comment, he didn't investigate or speak to a plow driver for a year and a half. That defeats the purpose of defining the value for which this is being omitted. I do have some issue that it's really not under the context of Bowden, because this doesn't have to do with the adequacy of a police investigation. It has to do with bias. And that purely is the state of mind of the person who made the comment. I would not get in the way of confronting the witness about their bias if they were called to the stand. But to put it in this way invites speculation, it invites manipulation, and it invites a party on either side to portray this in a way that is not factually viable. It will be distracting, confusing for the jury, and it could be unfair for either side because it will lead to arguments about what it means without a factual basis. And so my position is I don't necessarily disagree that it's relevant, but it should come through Michael Proctor. And if the defense wants the value, they should call Michael Proctor.
Okay. Mr. Yannetti, do you want to respond?
I know we're the hour's late, Your Honor. I won't belabor the points. I would state the following very as succinctly as I can, which is, yes, it goes to bias, but it also goes to the adequacy of the evaluation. The two concepts are intertwined. If you're biased or exhibit bias, the defense should be able to argue that the investigation was not adequate. I would note Mr. Brennan is not sitting at defense counsel table in this case. We appreciate the offer to help us with strategy about which witness we should call, but that's solely the province of the defense to determine which witness we want to use to authenticate and admit text messages. That's our choice, and we should not be deprived of that choice because Mr. Brennan thinks there's a better witness that should have introduced the text messages. There is no rule. There's no best witness rule in this case. I believe my co-counsel has already made that argument in another circumstance. His arguments, Mr. Brennan's arguments, go to the weight, not the admissibility. He is fully entitled to cross-examine this witness about all of the points that he raises, and in conclusion, Your Honor, he complains that we have not called Michael Proctor. I think that's the whole impetus for this objection, so that we will call a witness that they do not have confidence in to call themselves. It's unheard of in a murder case that you don't call the lead investigator, but that's what's happened in this case. We should not be forced to call Michael Proctor so that Mr. Brennan can then cross-examine him and lead him through basically his entire closing argument. He is entitled to call Mr. Proctor in rebuttal. He has every right to call Mr. Proctor again. I would rest on that. Thank you.
Okay. And just the very last thing, there's Commonwealth's motion for reciprocal discovery. Is there any objection to that?
Yes. No, it's not in compliance with Rule 14.
Okay.
We don't have any written communications with Ms. Dever, and they've asked for all oral communications to be reduced to writing and to be turned over. That's not in keeping with Rule 14.
All right, so you're saying two different things. So you don't, this information doesn't exist because she has not had communications with you, right?
Written communications do not exist. I'm not saying two different things. Written communications do not exist. They also ask secondarily for all oral communications to be reduced to writing. We have no obligation to do that. We have no intention.
All right, so I'll get a decision out on that before 4:30, and I'm going to do a little more research on the text messages. Want to be heard, Mr. Brennan?
I thought you were standing up, Your Honor. No.
Oh, no. Okay. All right. I'll see everybody Monday morning.
Thank you.
We're out of here. We're out of here. All right. So the lady who came in just briefly, Miss Dever, the Commonwealth has filed a motion requesting reciprocal discovery, saying, show us what you've got from her. And they say, we don't have to give you anything. Defense says, we don't have to give you anything because there's nothing. We haven't written a single text message back and forth. We've only spoken orally. And Rule 14 doesn't cover that. We're not going to reduce our conversations to writing, thus they be discoverable. We have no intention of doing that. And we're not going to give you anything. You just have to just wait and see what happens. So they're trying to pull a fast one here. They don't know. They don't know what she's talking about. So a lot of fun. A lot of fun there. What a day. What a day. The judge is going to make some rulings. We'll probably have some new documents on the docket regarding some of these things shortly, if she makes a written ruling, or maybe she won't reduce that to writing either. But it seems now that defense was bluffing when they said, if you don't call him, we will, when they were talking about Michael Proctor. And
Call from Angela.
Angela, I haven't heard from you all day. How are you doing?
I'm doing good on my way home from work again. It seems like I missed a hell of a day.
Say that again? Sorry, I was scratching my headphones and all I heard was scratch, scratch, scratch.
Sorry. It seems like I missed a heck of a day.
You did. Oh, heck of a. It sounds different the first time you said it. Yes, it's been a wild one. Some great back and forth, good lawyering on both sides, both by Brennan and by Mr. Jackson.
Jackson, yeah.
Jackson did the direct.
Yeah. Yeah, like yesterday and the day before, X and Discord kept me very well up to date on what's going on. So it felt like I was watching, even though I wasn't.
Yeah, great stuff. The first day of the defense case did not disappoint. Had some great testimony, great criticism of the witnesses who are fresh in our mind from the prosecution's case, and spicy back and forth. A good foundation here. So we're ready for day 2.
Yeah. I have a new nickname for Brenner, but I'll not say it out loud.
Thank you. We try to be respectful for everybody involved in the court case, judges, lawyers, witnesses.
Yeah. But it has something to do with the way he's objecting. So yeah. But
now I know what you were thinking, and Angela, you cannot say that.
Well, I have a...
Okay.
No, sorry. No, back to... I love I started watching direct of the Disorga guy.
Yeah.
And I love the way he is testifying. He's testifying the way that anyone can understand it. I haven't come long, but as far as I he's testifying very clearly. Total opposite Burgess and Welcher. They were so technical right from the start. Well, he is testifying the way anyone can understand it. It may have changed later on, but so far, all good.
Yeah.
And I love it, actually.
I think he was a good witness that way. He was good for the jury, meaning that he was easy to understand and clear with his answers. I also think that he was not trying to hide his answers, and he was direct, even when the answer was not making him look better or strengthening his position in some way. So I think he was a good witness that way.
Yeah, and I love, he understood that Jackson had a hard time because of Brennan's objections to his questions, which I understand they were leading questions. So he was doing his best to answer without making and he understood that Jackson had a problem, and then his answers backed Jackson's questions, answered the way again that I think it was really good back and forth, basically, even when Jackson had the problem with Brennan's objections. Yeah. And yeah. I am so sorry. You
need to change your work schedule. We need you on during so you can follow everything as it happens. It's one thing to get updates on Twitter, but today was a really good day, and it looks like it's not going to disappoint. We're continuing when we start on Monday. We've got these witnesses. We're getting possibly into the text message chain with Proctor with this witness. Depends on what the judge rules tonight. It was interesting that the judge said, I haven't decided on admissibility yet, and in a way the prosecution already says, well, we're not against it except for 3 little points. So they're if it's a stipulation, it pretty much comes in. For the judge to hold it out after both sides have stipulated, that would be unique.
You know what would be fun? That defense calls Brennan's bluff and calls Proctor just because, that would be fun. So yeah.
I think they would call him. I don't know. They literally told why they would not call Proctor. We heard that from Mr. Yannetti. They say they want us to call him so that on cross they can lead him through his entire closing and basically give 2 closings.
Yeah.
That's why we don't want to do it.
I understand that. Regarding unfortunately, I cannot change my schedule. It's firm schedule, and I was joking that I'm looking actually for a new job. And when I say why I'm quitting this job, I would not say because I found a better paying job. I would say because you ruined my plans for June because it's
I'm
not.
taking a pay cut, but I get to watch court now, so it's like an increase.
No, actually, if I find a better job, I'll get a raise. And I'll still get to watch court, whichever trial is at that time.
Yeah, awesome.
I think Koberger, at least.
Koberger's coming up.
So, yeah.
Unless they get a delay, we'll see how that one comes out. But good stuff.
Yeah.
Angela, thank you very much. Anything else you wanted to share before you go?
No, have a nice weekend, and I'll be going back and watching this morning court. So
enjoy. Leave some comments on YouTube.
Thanks.
Thank you very much. We'll see you.
Yeah, I will. Thank you. Bye-bye.
All right. Yeah, she's not going to tell you. She's not going to put it in chat. I'm not even going to type it in mod chat. I just know where she was going. All right. I liked today. I liked it. I think defense won some points. I think the Commonwealth gained some ground and maybe chipped away at some of the defense points today. It's no question that the defense experts made a mistake, and this guy cited it in his report, and then the Commonwealth experts changed their report, and then now he's, so I don't think it moves the needle a ton one way or the other. I don't think anything we heard today in testimony was earth-shaking or new in that regard. But it's been fun, and it's getting better. It's getting better. I love it. Any other comments or questions we can answer for y'all before we wrap things up for the day and excuse you for the weekends to get underway with all your weekend activities, whatever they may be? Chipped away at Chip. Let's see. Karen said that the defense team will address her statements to put in context. Okay, so I heard that, and I hope that's true because I think it's fair to play in context some of those comments that were played. The flip side of that is I think they have to play the bad part with the good part again. So the bad part gets played a second time, which sort of helps the prosecution, but you just have the good part to sort of put it in perspective. I think it's fair out of rule of completeness, and I think that gets around, hopefully, the hearsay rule. Maybe. We'll see. When does the Koberger's trial start? I think it's slated for August 11th currently, but defense is asking for more time. So we'll see. Nothing in this trial has been fair. I don't know. As much as we like to yell conspiracy and everybody's corrupt, this isn't a terrible judge. I know. Don't crucify me over this one. This isn't a terrible judge. Judge Cannoni is an experienced judge. She is making reasoned decisions that have to stand up under appellate review. I wouldn't agree with all her decisions, but there are very few judges that I agree with all their decisions. Her style's unique. She sighs a lot, things like that. I don't think that makes her a bad judge. I think she shows some bias. I'll say that. And does that make you a bad judge? I think that makes you a human. The best judges. Judge Carroll out of Florida, amazing guy. Memory, mind like a trap. Can remember anything from years ago, even filings that somebody filed and who argued what at months ago. Incredible. Still showed bias. Got angry. Had to excuse himself to calm down. Judges are people too. Right, and they're allowed to have bias. They need to sort of make sure it doesn't affect the jury, and the little bits we've caught I don't think have been major. So that's where I stand on that one. I like this case. I like the people involved in this case. Let's see. Ari, have you not seen the Microdots video of the initial hearings that she completely just went against the defense, especially with the data that they were requesting for months and months and months? It goes both ways on that. I've seen some of that. Once again, that happened in Maya as well. Let's see. It's worth watch. let's see. Amber deserves a raise and has done the outro twice, so it's time to go home. I guess I should play the music. She's done the outro twice. Where was it? Where was it? Okay, there it is. Tonight when you go home. There we go. There's the outro. Twice. 2 times. Do you have this on copy and paste, Amber? Because it looks like identical. You've got it on a clipboard somewhere. And you just throw it up on the screen there. There it is again 3 times. All right, I'm going to have a great weekend. I hope you will as well. I don't know where we're going tomorrow, but bathroom remodel is probably happening as well. So one day I will finish that and I'll stop talking about it. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe until we go live again tomorrow. Not tomorrow, I promise. Taking tomorrow off. Monday morning, regular time, full day in court, day 2 of the defense. This is going to be day 25 of trial. I hope I done those numbers right. It's going to be absolutely wonderful. You don't want to miss it. Please come here to watch. We'd love it. Easiest way to do that, click the subscribe button if you haven't right now. I mean, really, why not? All your friends are here already. Ring the bell so you get notified when we go live, and then join us. Keep us company and share your insights and experience in chat. Wait. Oh, yes, Trial TV tomorrow. Don't let me forget. Around 1 o'clock or so. That'll be on their channel, Trial TV Live. Big celebration. That's their year mark. So that's fun. Tomorrow I'll do that. I think I'm good there. And then I've got like the graduation thing in the night. So it's good. All right. You guys have a good weekend. Be good to each other. And we'll see you on Saturday at Trial TV Live and then Monday back in court. Have a good one. Bye-bye.
I was told counsel wanted to see me at sidebar.
Thank you, sir. You're my new best friend.
Josh, what do I have to wait?
Because he's the guy.
What do I have to wait for? Wait. Judge says she's coming back.
I'm not a cat.
Feeds
Have
are
them
down.
send someone with more experience.
The feeds are down. I think we're done. We're done.
Thank you, Mr.
Yep, we're done. All right. Bye.
I'm not going to argue about semantics here.
There's nothing in the order that restrains you from talking to cats.
Thank you.